in relation to holding persons accountable among the two leading political parties since 1992, the Fourth Republican dispensation. Kay, you have it. Walk us through it.
Yes. Since the ruling came yesterday, there's been a lot of conversations and comparisons, and one of the things we saw was a picture of Chairman Wontumi, that's Bernardine Chibuesiakon, and several pictures of many others, with a comparison being people or persons, politically exposed persons who have been convicted during the NDC regime previously and now, and same during the MPP regime previously. So if we go deep into it, we would realize that under the MPP, public officials and political figures convicted currently stands at one conviction, which is Bernardine Chibuesiakon, Chairman Wontumi, and exonerated and acquitted, none has been identified. If we look at the NDC end of the same, we have convicted persons in the person of Kwame Pepra, who was convicted in the quality grain case, Abuga Pele, who was convicted in the Jida case, though his conviction was later overturned on appeal. And then we have Dr. George Sipayanki, Sedinam Tamaklo Etienu, Eugene Bafuboni, Matthew William Tete Tevi, Alhaji Salifu, Mimina Osman, Ibrahim Adam, Daniel Duku, Frank Abuaji Mensah, and Irene Anti Mensah. So those are 12 convicted persons under the NDC. And then convictions over 10 and acquitted, discharged as well. We have Chachu Chikata, who was convicted in 2028, conviction overturned by the Court of Appeal in 2016, acquitted and discharged. Then we also have Dan Abodakpi, convicted in the quality grain case. Later, the conviction was overturned on appeal. And then we also have Nana Owusu Ensau, acquitted and discharged in the NCA case before judgment against the remaining accused. So currently, we have Wontumi's conviction, which remains a subject to appeal. And then Sedinam Tamaklo Etienu, who was convicted in absentia and later extradited to serve her sentence. And then we also have the Daniel Duku, Frank Abuaji Mensah, and Irene Anti Mensah, who were convicted after entering guilty pleas under the statutory restitution procedure. So this ledger basically is to distinguish between the final convictions later overturned, and acquittals and discharges. It does not treat all cases as though they ended the same way. Now we go to the part one of the ledger of facts itself, just so we can have a proper understanding of the Wontumi case, from presidential exoneration to judicial conviction, the Akonta mining chronology. So on the 5th November 2010, Akonta Mining was incorporated for mining and mineral exploration. Then in 2011, Akonta progresses through statutory licensing, reconnaissance license in 2011, prospecting license in 2012, and then mining leases granted on 23rd July 2021 for Samra Boy and Abokwase. Then in 2021 to 2022, co-director Kwame Ntwi travels outside Ghana and is no longer actively involved. So no functioning board or corporate governance. Wontumi becomes the sole controlling mind and hand of Akonta Mining. Then on the 25th of August 2022, Akonta Mining applies for a mining lease inside the Tano Nimri Forest Reserve. The application was not approved. So if we come to 30th September 2022, the Lands Minister Samuel Abujinapo orders Akonta Mining's operations inside Tano Nimri to be stopped. Then the valid lease in parts of Samurai Boy, no mineral right in Tano Nimri application was not yet determined, and any activity there was illegal. Government's position was clear and explicit. Then on the 4th October 2022, the Minerals Commission confirms publicly that Akonta had no lease, permit, or mineral right to mine inside Tano Nimri. Its 2021 leases were outside all forest reserves. So in October 2022, civil society organizations, including Occupy Ghana and the likes, intensify pressure. They demand criminal investigation and prosecution instead of administrative action. And on the 4th January 2023, President Nana Akufo-Addo makes the now very popular statement: Akonta Mining is not engaged in any illegal mining anywhere in Ghana as we speak. So the key factor is presidential assurance, which has now been interpreted to be moot because it does not establish judicial acquittal. Then we go to the part 2, the Samurai Boy concession. We look at events from 2024 to April 2025. So in September 2024, Henry Okum, a licensed small-scale miner, checks with Minerals Commission and discovers the Samurai Boy concession belongs to Akonta Mining. He contacts Chairman Wontumi. Then, between September and October 2024, Wontumi and Okum reach a verbal oral agreement, no written agreement, oral. Okum's account is that he's allowed to mine unworked parts, reclaim degraded areas, fund reclamation from mining proceeds. Wontumi's account also says only land reclamation, plant coconut seedlings, and no mining authorized. Now, in 2024, no application is made for minister's prior written approval as required by Section 14(1) of the Minerals and Mining Act 703. Then, in the same 2024, Okum and his workers move into the Samurai Boy concession. Mining and reclamation activities begin. The core dispute was this mining or merely reclamation? And then in the same 2024, Akonta Mining, there's a court later finds Wontumi did more than give access. He permitted the operation, introduced Okum to an excavator supplier, used Akonta letterhead, and listed RegSec protection. And on the 16th of April, police launched a major anti-galamsey operation in the western region. On the 17th April, police raid the Akonta Mining concession, arrest Michael Jedu AEC and 28 others. Items that were recovered were 29 excavators, 25 serviceable, 4 unserviceable excavators, 8 pump action guns, 1 single barreled gun, 310 cartridges, suspected gold, 4 motorcycles, 2 vehicles, water pumping machines, machetes, and 157,000 Ghana cedis in cash. This shows that this was a large-scale mining operation uncovered. And then in April 2025, Michael Jedu AEC tells police that Henry Okum is his employer and in charge of the mining activities. Henry Okum tells police that Wontumi allowed him onto the concession to mine gold and that he believed the concession belonged to Wontumi personally. This part of the chronology concerns events in 2024, April, and 2024 to April 2025 at the Samurai concession, separate from the 2022 Tano Nimri Forest Reserve.
And that's an important distinction that ought to be made, right?
Yes.
That there are the two cases are completely different. and have no bearings at all with each other.
Yes. So we go to the part 3. That's the investigation, charges, and the criminal trial. And in April 2025, investigators traced permission to Wontumi through statements from AEC and Ukum. No ministerial approval was granted. So no ministerial approval is found for any third party to exercise mining rights. And then in the same year as well,
The Republic, he was arraigned before the...
yes. So if we move on to the next one, we see here that the Republic arraigns. No, not the part 4. The part 3. We are still on the part 3. Please, easy with the scrolling. So we see
7th
on
October.
7th of October, the Republic arraigns Bernard Ntwibosiakon Wontumi and Kwame Entry at large and Akonta Mining Company Limited. 6 charges filed. Count 1 to 3, unlawful dealing with mining mineral rights, and count 4 to 6, purposely facilitating unlicensed mining. Now, in October, between October and November 2025, prosecution witnesses were 4 in total. That's Michael Jedwe Isi, Henry Okum, Chief Inspector Safo Isiedu, who was with the operations, and then Joseph Iroko from Minerals Commission. Then in November 2025 to January 2026, defense witnesses, 5 in total. That's Bernard Ntwibosiakon Wontumi himself, Wisdom Edem Gomashi, who is a mining engineer, and George Miriku Duka, former Deputy Lands Minister, Kwabena Ochreda Akumensa, former Western Regional Minister.
And then one Evans Adey.
One Evans Adey. Then we go on to April. That's January to April. We see the court scrutinizes the reclamation explanation. Reclamation costs money. Wontumi gave Okum no funds. We're still on 3. Yes, he gave Okum no funds. Okum is a miner, not a reclamation contractor. No competence check, no supervision. And then Wontumi never visited the site. The key factor is court finds the reclamation only story lacks commercial sense and is an afterthought.
That was a very important aspect as well, if you read
yes. And then from the April to May 2026, in final submissions, the defense raises a constitutional objection. They argue sections 14.1 and 99.2b of the Minerals and Mining Act 703 are vague and violate Article 1911 of the Constitution. Constitutional challenge seeks to halt proceedings and refer questions to the Supreme Court. However, in May 2026, High Court rejects the constitutional objection. Offenses and penalties are clearly expressed in law. Trial court need not down its tools, and any complaint can be pursued on appeal. So the case proceeds, no referral to the Supreme Court. Then between May and June 2026, court gives key legal findings before judgment. Dealing with mineral rights is interpreted broadly, allowing another person to exercise exclusive rights without approval is unlawful. Akonta Mining's corporate veil is pierced, and Wontumi is the true controlling mind and hand of the company. Law and facts align against Wontumi and Akonta Mining. The critical legal turning point in part 3 is the reclamation defense collapses under cross-examination. Constitutional objection is rejected, and the broad interpretation of mineral rights established, the corporate veil pierced, and personal liability established. Then we look at the part 4, which has been a matter of controversy since yesterday. The judgment, sentencing, and the aftermath. On 20th July, which was yesterday, the High Court judgment was given. Justice Audrey Kokuvi Tay of the Accra High Court, Criminal Court 4, delivers judgment. The court convicts Bernard Entry Boisiakon, aka Wontumi, on count 1 and count 4, Akonta Mining Company Limited on count 3 and count 6. The court finds that Wontumi permitted mining, not just reclamation. He purposely facilitated the unlicensed mining operation. Akonta dealt with its mineral rights without the minister's prior written approval. The key fact here is 2 offenses proved against Wontumi.
Right.
2 corporate offenses proved against Akonta Mining itself. And then on the same yesterday, Wontumi sentenced for count 1, dealing with mineral rights without approval, 20 years imprisonment with hard labor, and a fine of 10,000 penalty units. In default of payment, 3 additional years imprisonment. And then for count 4, purposely facilitating unlicensed mining, another 20 years imprisonment with hard labor.
Right.
The fine, 10,000 penalty units. In default of payment, 3 additional years imprisonment. The court orders the 2 prison terms to run concurrently. So if not for the court ordering the 2 to run concurrently, that would have meant
mostly they run concurrently. So I want us to round up because our guest is in studio with us already this morning.
Yes.
So at least from there, 3 things I can deduce. 3 persons or 3 accused persons: Wontumi, Kwame Entry, and then the company.
Yes.
Kwame Entry has been at large for some time, and so the corporate view was pierced, as we saw from the 3rd fact sheet, amongst many other things, which put liability on the laps of Wontumi as well, and is the basis upon which he is to serve that 20-year jail term and then pay the penalty, which is amounting to in excess of 300,000 cedis, amongst other things. I want us to go to the concluding part because a number of these details as well we've reiterated throughout today as we've been having the conversation. So let's go, Frederick. Let's go to the concluding part.
Yes, so the concluding part, the company is fined on both corporate counts. That's the Akonta Mining itself. That's 15,000 penalty units for count 3 and count 6 as well. So the total fines are 30,000 penalty units. We look at the historical contrast, the 2 controversies. That's 2 very different outcomes. If we look at September 2022, government says any operation in Tano is illegal. January 2023, President Akufo-Addo assures that Akonta Mining was not engaged in illegal mining. In 2024, separate oral arrangements made concerning Samra Boy concession. In 2025 April, police uncover the large mining operations, and in July 2026, High Court convicts Akonta Mining and its controlling director,
right,
Charles Entry Boisiakon.
Right. Kay, appreciate these facts as they've come forward, and I'm sure even tomorrow and going forward, there'll still be conversations in relation to this greatly as to what becomes of him. At least we know from this morning that he's in Sawam, has begun serving his term. Palgrave tells us he's visiting him, he's making arrangements to visit him as well, and so we'll get a bit more from that. That's Cudjoe with me in studio this morning as well.